Foundations to Understanding Student Rights on College Campuses. You may have heard classmates and friends say that you have a First Amendment right in academic freedom. You may have heard the term thrown around, a right to due process. You may be under a campus investigation for certain things you said or did, and may be asking, what can you do about it? Any time that a student faces charges by university officials about student misconduct, they must ask themselves certain foundational questions. Caveat: this is not legal advice. First, ask whether you attend a public university or a private college. If it is a public university, you will more likely have constitutional rights applicable to your case. If you attend a private school, you will have the minimum constitutional rights. In either situation, you may also have contractual rights, or possibly state or federal legislation available in your aid. Next, you should ask, 1. Whether your case falls within the decisions of the United States Supreme Court. 2. What circuit court precedent decisions apply to your case, and what state court precedent decisions apply to your case. If you are the plaintiff, then you can sue either in the federal court, where circuit court decisions mostly apply, or you can sue in the state court, where often both federal and state court case law will apply. In the event that a student chooses to sue in a state court, a defendant college official may attempt to remove a case to the federal court, but that is better dealt with in another video. For now, it's important to understand that the case law of the state can be more favorable to a student than in the federal courts in some cases, and vice versa in other cases. But all these courts must follow the precedents of the United States Supreme Court on matters of U.S. constitutional interpretation. Part 1. So now, for the first major question. What United States Supreme Court decisions apply to your case? In this video, we will not be able to discuss all of those landmark cases. However, we will break them down into simpler and more easily understandable categories. There is only a select group of constitutional amendments that apply to college students, and each is a separate category within the whole of pertinent Supreme Court precedent case law. Those amendments follow. The First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. For now, just understand that generally speaking, a public university cannot interfere with students' rights to exercise their religious beliefs, to publish their ideas in the school newspapers, or other forms of speech they have ever expressed. The Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. As far as the Fourth Amendment goes, simply imagine how this will apply to a student living in a college dorm, and look for subsequent videos where we will discuss it. The Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The Ninth Amendment protects the rights of students that are not explicitly stated in the Constitution. Specifically, certain constitutional rights have an implicit existence based on the interpretation of the text. The 14th Amendment. Section 1. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 5. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article. It is important to see that specifically within the Section 5 of the 14th Amendment, There is given to Congress the power to make legislative rights that expand rights of students under the 14th Amendment, so long as such legislative action has not been barred or limited by another place in the Constitution. For example, the First Amendment says, "Congress shall make no law abridging the freedom of speech." This means that while Congress can make discrimination illegal, it cannot make laws that abridge speech that violates other persons' equal protections of law. In other words, Congress cannot make laws that prohibit hate speech or speech that denigrates the rights of others. This limitation applies equally to the states and their universities under a legal principle that we may later discuss, known as incorporation. The alternative means that the courts and state universities have used to handle similar speech issues has been through placing the prohibition against the act of harassment, which we can discuss in another video altogether. Also, look for our upcoming videos on the scope and rights of due process and equal protections in the university. Here are other rights that do not necessarily apply to students in universities. You may read through them, though they have no application in university law. We will not discuss them further in this video. Rights that belong to the public university. Yes, that's right. In addition to giving rights to student individuals through ratification of the Constitution, the forefathers of the United States had also given the states, as separate entities, rights of their own. And because public universities are extensions of the states, that means they are entitled to those rights that belong to the states. It follows. The 11th Amendment. The judicial power of the United States shall not be construed to extend to any suit or law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. In a nutshell, this makes states immune from suits, and through it lays the foundation for state sovereign immunity. Here, sovereign immunity means the state cannot be sued directly when the public university fails to adhere to the rights of students. In other words, the student plaintiff must sue the public university officials who are most directly responsible in causing the student's rights violation. This also means that although a public university official may be found to have violated a student's rights by a finder of fact, the court may still find that the public university official has sovereign immunity from punitive liability. For example, suppose a public college decided to expel a student for publishing a school article about why people should distrust feminism. In such a case, the finder of fact may decide that the school's decision-makers and the other causally related school officials did in fact violate the speech rights of the student, but the court may decide as a matter of law that sovereign immunity applies to the university official. The only thing the student will receive instead will be the remainder of the education they're owed and no financial compensation for the student's losses caused by the college official. This can be discussed in further detail in another video. Part 2. Now, what circuit court precedents apply to your case? What state court precedents apply to your case? Since we have thoroughly isolated college student rights based on precedents of the Supreme Court in the simplest way we could, we now will take a quick look at the role of circuit courts and the state courts. In comparison to the Supreme Court, the states and circuits handle the vast majority of these cases. If there happens to be a case that is on point and not distinguishable from the issue in your case, chances are that it will be found in either the state or federal circuit case law. One perk to state case law is that states have their own state constitutions, and because circuit courts cannot make decisions that involve state constitutions, this means a student may prefer to have their case heard in the jurisdiction of the state court. Such relevant case law may be provided in subsequent videos. However, what if the issue that the student has with the college is so unique that the Supreme Court has never made a decision on that kind of issue before? For example, in some cases where a university has expelled a student for making inappropriate posts on Facebook, and the school made rules that would severely punish him for so-called unethical behavior in a manner that contravened the student's liberty to speech. Here, it would seem the Supreme Court has made decisions similar enough to provide an identifiable answer. However, in 2016, in Keefe v. Adams, a circuit court decided this same issue had not been heard by the Supreme Court, and that the circuit court had the power to decide it its own way. The Supreme Court can refuse to hear the appeal notwithstanding how poorly the circuit court had decided the case. States generally attempt to rely on the decisions of the federal circuit in which they sit. Any state decision on an issue of the federal Constitution can be appealed to the federal court. On a single constitutional nuance that the Supreme Court has not yet decided, all the different circuit courts can have an entirely different opinion. As a result, some constitutional case law will seem like a quagmire of inconsistency. Conclusion. At any rate, having watched this video, you now have the foundation for learning to assess whether your rights have been violated by the university. The next step will be to learn the scope and limitations involved when you actually apply the First Amendment, Fourth Amendment, or the 14th Amendment, as well as your Ninth Amendment implied constitutional rights to the specific facts of your case. Keep in mind, none of this is legal advice. You should always consult with a specialized lawyer of this area before ever handling a potential university student misconduct investigation against you, before having a meeting with a university official on a matter of student misconduct, and in any related correspondences with the university. With that in mind, please see our next videos on specific cases that may be determinative for your case, and learn also what arguments will carry the most weight when talking to a university official.